Good morning, everyone, and welcome to today's webinar that's called Getting Your Fees Approved, Current Trends and Top Tips. My name is Lucy McCann. I'm delighted to be your host for this session. Thank you for taking the time to join us. The practice of court reporting of IP's fees arises actually as a result of convention and practice in Scotland, and it's an area where we are uniquely different from other parts of the UK. The last decade has arguably seen a more proactive approach from the courts when dealing with office holders' fees. And in today's webinar, we will consider what we can learn from those decisions, the impact of the job of court reporting, and how best to ensure that you're paid as IPs for the work that you're doing on your cases. I appreciate that approval of fees is a topic that's close to every insolvency practitioner's heart and indeed pocket. The process of fee approval will always involve a balance between the need for fair compensation for practitioners with the requirement for transparency and accountability for creditors. The court's more proactive approach to fee approval has presented certain challenges, both to IPs and to court reporters, which we hope to explore this morning, but also hope to share some top tips that might actually help in getting fees approved in the future. I'm very fortunate to be joined today by my colleague Andrew Scott, who through his numerous years in practice has, along with the rest of our team, developed an extensive expertise in acting for IPs, seeking approval of remuneration and dealing with contentious insolvency matters. I'm also delighted to be joined by Eileen Blackburn, who will need very little by way of introduction. Eileen's been a practicing IP for 30 years, including acting as a court reporter. She sits on various technical committees, and since her retirement from heading up a very busy IP practice, she now specialises in court reporting. And as I said, I'm really delighted to be joined by them due to their extensive experience and expertise in this area. So without further ado, let's get started. Andrew, before we look at some of the recent decisions, can you set the scene for us and take us back to basics? Can you remind us why we have a court reporter in the first place and what role they play in fee approval?
Yeah, thanks, Lucy. Good morning, everyone. As many on this webinar will know, when it becomes necessary to apply to the court for approval of fees, the practice of the court is to remit to a reporter. That reporter will audit the IP's accounts and report on the amount that should be paid for outlays and remuneration. In the court of session, the court will also remit the question to the auditor of court, who will also produce a report, and then both reports will be considered by the court before issuing a determination on the level of fees that should be taken. Now, the practice of remitting to a reporter has no statutory basis, and in many ways that might be the reason for some of the challenges and issues that we'll go on to discuss later in the webinar. In a case in 2011, Lord Glennie noted that the practice appeared to have emerged at the end of the 19th century as a practical means by which the court could be properly informed before making its determination. So it's a practice that has been on the go for quite a while. And while that practice can be departed from in appropriate circumstances, there is situations where you can dispense with it. The court has found the practice to be there for a good reason, and the court will often find that it's a helpful way to assist it in helping to balance the interests between secured and unsecured creditors. The level of fees claimed can give rise to concerns, and as Lord Glennie remarked in that case in 2011, the court will be astute to guard against office holders being rewarded at the expense of unsecured creditors. It will generally wish to examine the claim for outlays and remuneration critically, and will also want to ensure that an IP who is obviously an officer of the court is properly remunerated. And the court recognises that it cannot necessarily do that without some assistance from those who are used to dealing with questions of the reasonableness of legal and accountancy fees, and therefore it becomes appropriate to remit it to a reporter for those reasons.
Okay, perfect. Thanks, Andrew. So now we understand why the court remits matters of an IP's fees to a reporter. What has the court had to say recently about the role that they perform?
Yeah, so there have been a number of decisions over the last, I would say, 10 to 15 years, which I think, demonstrate a more proactive, a more interventionist approach by the courts on this issue. I can't go through all of them for this morning, but I want to look at four cases that I think kind of trace the approach of the courts. And the first, I think, goes back to a decision of Lord Malcolm in 2013. This was when he was asked to approve the remuneration of provisional liquidators in St Margaret's School in Edinburgh. Lord Malcolm noted that the court could not just reject the evidence, reject the advice of the reporter or the auditor without what he called cogent and objectively justifiable reasons for doing so. He did remind everyone, however, that the final decision on remuneration remained one for the court and for the court alone. The liquidator, as we've said, is an officer of the court. The court should have the ultimate decision on the liquidator's remuneration, according to Lord Malcolm. And he also made the point that the court provided a safeguard when it became apparent that something had gone amiss. So in many ways, if there had been any perception that the court was just there to rubber stamp the court reporter's report and the auditor's report, that was very much put to bed in the St Margaret's School case. Lord Malcolm also kind of helpfully set out some principles which were to be applied by the court in determining remuneration. These will be familiar to many again on the call this morning, but it's worth just flagging those. The office holder must tender and be able to justify an explanation of what they have achieved. That's the burden that is on them to do that. Any element of doubt as to the appropriateness or the fairness of the claimed fee should really be against the appointee. But weight should also be given to the fact that the appointee is a member of a regulated profession. That's something that the court will take into account. And I think, importantly, the other principle that Lord Malcolm emphasised was that the fee should reflect the reward and value of the service rendered. It's not simply an amount to reimburse the time expended and the cost incurred. And that requirement that the fee should reflect the value of the service rendered is something I think we'll see coming through in some of the other cases as we go on. So that was at Margaret School. That was the first one. Moving on a few years to 2018, decision of Lord Bannatyne in equal exchange trading. In that case, the court reporter had raised a number of concerns regarding the liquidator's remuneration, and this led the judge to considering the extent to which, or the extent of the reporter's remit. That kind of followed a couple of sheriff court cases where that question had been raised. Lord Bannatyne held that the reporter's remit was not limited to merely checking whether there was evidence to support the work claimed for. The reporter was required by the rules to consider whether the work had been reasonably undertaken and could properly report to the court that that work had been unnecessary or inappropriate. That was within the court reporter's remit. Lord Bannatyne gave an indicative list of concerns that a court might expect a reporter to highlight, including potential compliance issues, potential fraud or bad faith in the conduct of the case, potential issues regarding the way in which a liquidation had been progressed, or even where, I suppose, more unusually, there's issues in the way in which liquidation had been progressed, whereby the actings of the IP was so unreasonable or absurd that no reasonable IP could have acted in those ways. Those were the sorts of things that the reporter could comment on. However, Lord Bannatyne was clear that the appointed reporter was not there to oversee the conduct of the liquidation in general, but really to flag those concerns. What the reporter was there to do was to consider issues of technical difficulty and complexity faced by the office holder and to advise the court using the reporter's experience and expertise on whether the appropriate level of staff had been applied to the various tasks. So importantly, in relation to the role of the reporter, what Lord Bannatyne was saying was that the liquidator had to be able to exercise their own judgment and discretion. A mere disagreement, as he called it, between the reporter and the liquidator in respect of the liquidator's course of action should not be raised as a concern. But there certainly was areas where it was appropriate for the reporter to raise concerns. The third case, which kind of follows on from that, is a sheriff court case, Sheriff Anwar in One Optical Limited. In that case, the sheriff was not satisfied that the reporter's report contains sufficient information to allow the court to properly be informed as to the correct level of remuneration. And therefore, asked for an alternative reporter to be appointed. That reporter raised a number of concerns with liquidator's conduct. And so again, the question raised in One Optical was what was the reporter's remit and how to deal with some of those concerns raised by the reporter. Sheriff Anwar had to apply the decision of Lord Bannatyne in equal exchange, and in doing so considered that the type of concerns which ought to be drawn to the court's attention were concerns which may have consequences. So either because of a failure by the liquidator to discharge his or her professional duties timelessly or efficiently or indeed at all, or because the actings of the liquidator had been or had the potential to have a detrimental effect on the creditors of the company. Again, those were the concerns that the court would expect the reporter to flag. It would also be where the reporter's concerns had not been addressed in discussions with the office holder, that those matters should be raised. So again, the theme coming from One Optical, following on from equal exchanges, that the reporter has to be robust in their analysis, but they must guard against simply disagreeing with a course of action taken by a liquidator or refusing to accept a reasonable explanation given by the liquidator. The reporter has to be able to robustly challenge the liquidator, but also to work constructively with them. And fourthly, and finally, in our tour of cases in the 2023 decision of Future Renewables Eco PLC, and again, for many on the call and the webinar this morning, that would be a familiar case, and there's been plenty of commentary and plenty of discussion. I don't really want to add much more to it than there has already been. We'll be familiar, many of us, with the judge's view in that case that the reporter required to make a proper inquiry into whether the outlays, which in that case was the legal fees, were reasonably incurred. For the purposes of today's webinar, I think the case is helpful for 2 points. What it says about the detail required of the work undertaken by the office holder, and also, secondly, the nature of the dialogue between the reporter and the office holder. So on that first point, Lord Braid was critical of the breakdown of time costs provided to the reporter, even going on to say that they raised more questions than they provided answers. The judge was not convinced as well that the reporter had given adequate consideration to the extent to which the work performed by the former administrators in that case had provided value, which again goes back to the point and one of the principles made by Lord Malcolm in the earlier case. Does this work actually provide value? So ultimately, the judge remitted the matter back to the reporter so that further information can be provided by the office holders and that further inquiry and investigation and analysis be carried out. It's probably interesting, just in passing, there was a disagreement between the two sides in Future Eco Renewables in relation to how the court should deal with the court reporter's report. I suppose the former administrator taking the view that it was only where the report or the court found that the reporter had clearly gone wrong, that it shouldn't be there. Whereas the current administrators took the position that the court could disagree with the reporter's advice only for cogent and justifiable reasons. I think what is interesting is that the court found that the clearly gone wrong was not the best test to apply, and again came back to this view that the court is there to make its decision. It's not a delegated decision to depart from. Ultimately, the report is just one factor, albeit an important one, but just one factor which carries a considerable weight to be taken into account by the court in reaching its own decision as to the appropriate level of remuneration and outlays. The second point, which I think is interesting from Future Eco Renewables for our purposes, is that there should be no negotiation of the level of the fee. Again, that was clear in what Lord Braid was saying. Again, there should be a dialogue, but certainly there should be no negotiation of the fee between the reporter and the office holder. So there's a whistle-stop tour of 15 years worth of cases, but I think some of the themes that you see coming out, I think are helpful for what we're discussing this morning.
Thanks, Andrew. That's really helpful. And it's this idea of it being an emerging area in terms of matters just progressing in each case, I suppose refining and telling us a little bit more about what the role is and how IPs can go about ensuring that they are paid for the work they do. And I guess that's a really good point for us to now bring Eileen in. Eileen, you were an insolvency practitioner for many years and have been appointed as a court reporter many, many times. do you think that the role of the court reporter has changed as a result of some or all of these decisions that Andrew has been speaking about this morning?
Yeah, thank you for that question, Lucy. I think the fundamental role of the court reporter remains the same, and that is to assist the court in deciding upon the appropriate level of fees and outlays. Andrew pointed out that it's an important aspect of the court's decision about the level, but it's only one aspect nevertheless, and the reporter is there to assist the court. And this was brought out, you'll recall, by Lord Malcolm in the St. Margaret's school case. Andrew's been talking about developing law over the last 10 to 15 years, and my observation there would be that we've seen significant improvements in good practice, actually, as well in adherence to regulation over that period of the last 10 to 15 years. I think that firms are striving all the time to improve service delivery, and they're obviously also acutely aware of the rigours of operating a professional practice under the watchful eye of the regulators. It's a constant battle to balance commercial interests against regulatory requirements.
Thank you. I guess obviously you sit with both your IP hat on as well as the court reporter hat, which may sometimes be different. But what challenges do you think that these decisions have created, either as an IP or as a court reporter?
Yeah, as you say, I've sat on both sides of the table. That was a really useful summary that Andrew provided on the decisions and pulling out the salient points from these decisions. I think as a result of this, we have a clearer view of what the court expects of a court reporter, which is extremely helpful. I mean, in the past, I think there would be IPs in some quarters that would take the view that the reporter's there simply to recommend a fee, and that they shouldn't be conducting an exercise similar to a regulatory review. Now, whereas I would always have agreed that reporters aren't there to supervise how liquidators choose to run their cases, or to second guess, in fact, what liquidators, and can I just use the term liquidators for simplicity here? Sometimes it would be, we'd be looking at administrations as well, but just for simplicity, we'll refer to liquidators. It's now clear, though, that the report is not limited to simply checking whether there's evidence to support that the work that was claimed for was in fact carried out. It's also necessary to consider whether the work was reasonably undertaken and to make sure that it wasn't unnecessary or inappropriate. Areas of technical difficulty and complexity also need to be considered, as well as whether the tasks have been carried out at an appropriate level.
I guess one of the points that's raised in future renewables was the interaction between the court reporter and the office holder. In your experience, how does this take place, and what actually takes place?
I mean, my personal experience, both as an office holder and as a court reporter, is that there is often a measure of interaction. Now, the scale of that will depend on the nature, how many issues there are that have been identified by the court reporter during the review. I mean, sometimes it's relatively straightforward and there's not an awful lot to discuss or to inquire about. Other times there's a lot more to go into, but in my experience, I was always accustomed to a professional and respectful exchange of correspondence and dialogue between the liquidator and the court reporter. But it seems to me that in some of the cases which did come before the courts, there clearly has been a breakdown of the professional relationship. And dare I say, the involvement of the courts could have been avoided in some of these cases if professional relationships hadn't broken down. If we look at future renewables, however, Lord Braid was critical of the court reporter And he said it would have been better had the reporter not contacted the petitioners to discuss his proposed reduction with them. Now, I do not entirely agree with that. I mean, for one thing, the ICAS checklist, which is adopted by most court reporters, would require the reporter to send a draft of the report to the insolvency practitioner for comment before it's finalised. Now, clearly, if the reporter is suggesting a reduction to the fee, then it could be predicted that the IP is likely going to come back with queries about that. So is it not better to address any possibly contentious points, including the fee, let's be honest, in an open and transparent manner? Also, if we look at Sheriff Principal now, Anwar's comments in the one optical case, she seemed to be suggesting that there should be dialogue between the reporter and the IP, and it should only be where matters weren't capable of resolution that these matters should be included within the report. Those being adverse issues, of course. I don't mean the straightforward parts of the report that would always be included. And Sheriff Anwar at that time said, the reporter requires to robustly challenge the liquidator, yet also to work constructively with him or her to ensure that the court is provided with the full facts in relation to matters of concern. So I think that probably explains it quite neatly. As I say, this would suggest that the courts expect a level of dialogue. Going back to Lord Braid, he also said that the fee is not to be subject of negotiation. And I mean, that's without question. Of course, it's not subject of negotiation. But it can be helpful to have dialogue if, for example, there's been a misunderstanding, possibly by the insolvency reporter, the court reporter, about certain aspects of the case. And it's as well to have those properly explained by way of useful dialogue.
With a view to potentially cutting down on the dispute that's live before the court in relation to the fee. Yes, kind of thinking about with your court reporter hat on, and with a view to helping the audience, what examples of bad practice have you seen that resulted in you recommending a reduction in fees?
Lucy, I never see any bad practice. That absolutely never happens.
Wonderful, resounding for the profession.
Absolutely, never any problems in my cases. No, seriously. I suppose my pet hate is the tendency to charge in half-hour units or more. I'm pleased to say, though, that following the St. Margaret's School decision, which was quite a while ago, I guess, this has largely disappeared. It used to be widespread, but rarely do you see that nowadays. I'm sorry to say, though, that the offenders that I do see tend to be the more senior members of staff and sometimes the liquidators themselves. So that's certainly worth having a look at. If there's a tendency to charge in big blocks, I tend to have a look at that. And I think most court reporters would. Another practice that tends to lead to reductions, I mean, this is probably, it's a lot to do just with the market and how busy people are. And sometimes you see perhaps change of staff and people moving around from one firm to the next. But an area where there can be reductions is where a case hasn't been progressed to closure in a timely fashion. And this is an issue for the regulators as well, I think, as the insolvency practitioners out there will know. So in the worst cases, you can see files being lifted and laid, passed from one member of staff to the other, reviewed, re-reviewed multiple times with no real progress. And the knock-on effect of that can be multiple annual progress reports, which report absolutely no progress, but simply add to the costs unnecessarily. So that's another instance where you can see fees being reduced. And we've also talked a little bit already about value for money. So it's perhaps self-evident that where you see a combination of high charge-out rates and a lot of time being charged, especially when it's a very straightforward case, it can be difficult to evidence value for money. So that's obviously a slightly trickier one and maybe not quite so straightforward to deal with. But at the end of the day, the report, which is prepared by the court reporter, is an opinion, and the court reporter is entitled to put forward their opinion if they feel a fee should be reduced because it doesn't demonstrate value for money.
I guess this idea of value for money and what that looks like is maybe something we'll come back to a wee bit later, depending on the time available this morning. But turning it into a more positive outlook in terms of your role as court reporter, when you're looking at files, what top tips can you give to IPs that will help them maximise the amount that they're actually able to recover for the work that they have done on their cases?
I mean, it's not difficult, and I don't want to sound glib. And if we do have some time later on, I might pick up some specific points, but just at a high level, do a great job, and make sure that you properly record all the good work that you do. If you're meeting your statutory deadlines, the job advances at a good pace, you get your asset realizations done quickly. That's not always possible, but get them done as quickly as possible. Carry out your investigation, do your reporting, hopefully pay a dividend and record everything properly on file, then you shouldn't have too much difficulty getting your fees approved. I do have some other points, but shall we just wait and see how the rest of the webinar progresses, and we can perhaps come back and we might even have some questions additional to deal with. Thanks.
Perfect. Thank you, Eileen. Thank you. So, Andrew, back to you, I think. So, turning now and looking at the process of applying for fee approval, what changes have we seen? Let's think a little bit more about kind of court procedure this time.
Yeah, I think one of the ones I wanted to kind of raise this morning is the 14-day period. So in the rules at the moment, we have 14 days after the end of the accounting period is the time by which an IP is to submit their accounts for approval and determination of the remuneration. Now, under the old rules, under the 1986 rules, for those who are old enough to remember those, it was shall, within 14 days, the IP shall. And that resulted in a number of applications for waiver of failure because, again, one of the kind of administrative burdens was that that rule would require the IP to submit their accounts every 6 months at that stage, with the accounting period being a 6-month period. Often that wasn't done, and therefore there was a number of applications that would be put in with a waiver, and at some points sheriffs got a little bit grumpy with constantly having to waive the failure to apply that because the rule was shall, and therefore the rule changed. The 2018 rules that we now have the word may, and I suppose I raise it here, and again, be interested to if there is any questions or comments, because again, our experience is that some courts are still almost reading the word shall there, and therefore even if an application is made out with 14 days, are having problems with that and asking for waivers. So you're having to actually apply to waive the failure, even though, strictly speaking, it doesn't, I think, be a failure because it's only a may. So that's kind of one issue I think that needs to be, yeah, it's just out there, but you have to be aware of it because some sheriff courts will take a fairly transient view on that.
Eileen, is that your understanding of the rules as well?
Yes, absolutely.
And what do you generally see in terms of when liquidators are applying for approval of fees?
I would say that the practice is mixed. Some IPs are submitting their applications promptly within 14 days at the end of the period. At the other end of the spectrum, still a practice with some IPs of applying for approval for multiple accounting periods. and seeking a waiver. I just think that maybe sounded a bit critical. It wasn't meant to, because I think that the intention of the court was to deal with just these sorts of cases where it might not have been commercially viable to draw up your accounts to the end of a 6-monthly period, and they preferred to wait until later, so they weren't having to constantly return to the court, and that's what it was about, as far as I'm aware. I'm also, though, more interestingly seeing cases where the accounts are not being brought up to date completely, and IPs are applying for approval of fees only up to the point at which they can recover their fees and not dealing with subsequent periods. So that, of course, would leave them without their intromissions approved until the case is closed. Not sure if that's a particular issue or not, but I'm just raising it as something that I'm seeing is happening at the moment.
Thank you. Andrew, what other procedural matters do we think that practitioners need to be aware of?
Yeah, well, I suppose in terms of the appointment of a reporter, again, people will be aware that there are different courts have different processes, which is not always ideal. It would be great maybe to have a wholly consistent approach across the courts, but we are where we are at the moment, where some courts will allow an office holder to appoint and nominate a reporter to review their cases. But if you're making your application to the Court of Session or to Glasgow Sheriff Court or to Aberdeen Sheriff Court, then you'll be aware that there is a list of reporters, and the court will generally not allow you to nominate a reporter in those situations, unless sometimes there could be a particular conflict with a reporter who's on the list, or one reporter might have done already previous accounting periods, in which cases the courts are generally happy to for the nomination in those situations. But with the Court of Session in Glasgow and Edinburgh, you have a list, and the court will appoint off of that list. It's interesting just to note that according to the list that's on the website for the Court of Session, there's 9 reporters listed there. I contacted Glasgow and Aberdeen earlier this week in preparation for this, and they are down to 3 reporters on their lists for that for both courts, due in some ways to retirals. The process, because again the practice of court reporting has developed from the 19th century, there's nothing written down here. There's no process by which people are added or removed, and certainly it's unclear in some ways how they will replenish their lists. But that's certainly something which I think will have to happen, certainly in Aberdeen and Glasgow in the relatively near future. And I'm aware and have aware that in getting engagement with the court service, and this can be tricky. I know that David Menzies at ICAS has been resolutely trying to write to the courts about this, and I understand they has recently received a letter back from Sheriff Principal, as Eileen noted, Anwar, of the One Optical case, who's now Sheriff Principal of Glasgow and Strathkelvin, with a view that they will be looking at this. This is a matter that they will be looking at, possibly with a view to reviewing that list over the summer. So it's a watch the space in terms of that, but that's something that certainly you need to be aware of in relation to the court reporter appointment method where you have lists. I was also mentioning when we're speaking about fees, it's also mentioning worth Section 204 notes. The most recently reported decision really on 204 notes is actually a 2010 decision of Sheriff Holligan, MHC Construction. A useful case to have a look at in relation to 204 notes that came out of a situation really where in a prior case, Sheriff Holligan had mentioned the fact that actually he seemed to think a Section 204 would only be appropriate shortly after the Section 138 meeting. And that caused a little bit of consternation, I think, within the marketplace at that time. In MHC Construction, I think he kind of pulled back from that a little and said, wasn't saying that was the only time it would be appropriate to make a Section 204 application, but certainly how quickly it would be made after that may be a factor on whether the court decided it was appropriate for the order to be granted. Again, the practice will differ between courts, but certainly the more further on you get in your case, the less likely a court might feel it's appropriate for that to be an early dissolution in that stage. And also in terms of fees, again, it's not consistent, but there will be a number of courts where they have a limit of, say, £5,000. And if your fee is, or you're looking to take assets from the estate above that to cover your fees, they will say, no, you need to go through the approval process and have a court reporter appointed in order to audit your cases. Now, again, that's not entirely consistent throughout Scotland, but again, it's worth bearing in mind that early dissolution is really for early dissolution, and you really, if you're above that £5,000 threshold, you're almost certainly going to have to get some form of formal approval of your fees at that stage. And I think the final thing I was just going to mention, and it was, again, it just relates to fees, but the case of PS trustees against accounting and bankruptcy a couple of years ago, that was all to do with the outlays. In that case, it was storage costs and whether it was appropriate to charge that. Again, a relatively interesting decision on whether that was a cost that should be absorbed by the IP practice or one that could be charged to the case. Ultimately, it was the former. It was to be absorbed by the IP practice, but again, an interesting case looking at the rules as to what was reasonable to be charged, and also looking at the ZIP 9. Ultimately, the court deciding that it wasn't appropriate in that situation for it to be absorbed.
Thanks, Andrew. Eileen, my question for you is about outlays, and actually we can pick up on the questions that we've had in from our attendees this morning.
Mm-hmm.
What supporting evidence behind any outlays expenses would, it says the speakers, but I think that in terms of the court reporter, what would you expect to see? So would you expect to see legal invoices based on time cost to be supported by time records and narratives? And what type of things are you looking for in terms of outlays to satisfy yourself that they're an appropriate charge?
Yeah, I mean, I suppose the question of legal fees, which can be a significant part of the overall expense in a case, came into focus in future renewables, didn't it? I hark back to the days when legal fees were taxed. It was a lot easier. It's a lot easier for me. And I think I've mentioned before that when Neil Crichton was the auditor of court, his first question when you went to confer with him was always, have the legal fees been taxed? And that was just tick the box and that, that was fine. Was the question asking specifically about backup? Is that what it was?
Yes. So what would you expect to see as supporting evidence behind outlays? So,
I mean, very often if the fees are substantial, a lot of the information will be in the file because the insolvency practitioner will already have asked to scrutinise it, particularly if a long-running legal case is going on and there are fees being raised regularly, then I do quite often see that there is backup within the files. And I like to see that. Of course, I like to see that. And I like to see that the insolvency practitioner is scrutinising the legal fees and making sure that they're happy with them. And I would tend to narrate that within my report that I had looked at it and I had asked about it. For smaller legal fees, I don't think I would probably go into that level of scrutiny, but certainly if they're substantive and particularly against the recent case law, yes, I probably would want to see a bit more.
And I think it's interesting as well that, again, future renewal talked about the fact that, I mean, ultimately did want the legal fees to be taxed in that case, but also wanted the reporter to consider the fact of whether they were reasonably incurred. So there's almost two stages to that. So there's, you can see supporting evidence, perhaps this is what the time was incurred and these are the costs that were incurred. But I suppose there is a role for the reporter to kind of say, well, should that have been incurred in the first place?
Yeah,
so was that appropriately?
Yeah, the reasonably incurred one was a big issue in that particular case. That thankfully that level of controversy doesn't arise that terribly often. But yes, yeah. You're right to remind me about the reasonably incurred aspect, Andrew.
guess, though, all of these questions that the court is focusing on about taxation, about vouching, be that for outlays or be that for the IP's own fees, I guess it's back to that kind of central point about value of the service that's rendered, isn't it? And to what extent was the work that was done for the benefit of the case, for the benefit of creditors, and how can that be demonstrated either by the IP in their file or by the court reporter in their report to the court? And I suppose there's a couple of stages at which point these things can be presented and explained, because ultimately from the court's perspective they are being presented with information that has come through a number of people before it gets to them. So they need to be satisfied that what has been done and what has been seen to be done and overseen through the process is properly incurred, which I think is an interesting point. And I guess one of the issues that was raised there was the list of court reporters, and one of the questions or one of the kind of points made in the chat is whether or not it's now time to actually have a more kind of consistent approach where you've got smaller panels of people, maybe 4 or 5 experiences, what the person who's asked the question is suggesting, to act as auditors and report across courts and ensuring consistency and integrity of the process. I guess that is maybe a matter for regulators to get involved with, but I'm wondering, Eileen, if you've got any particular views on that in your capacity as a court reporter, but also in your view as an IP.
Just having a look at the question, Lucy.
Yeah, and while Eileen does that, I think it's an interesting point. I also think
same piece
talks about whether there is
transparency.
Transparency. One of the points, I suppose, is yes, the court reporter's report is only a report for the court, and the court, and as I say, these are the theme that really comes through a lot of these cases. Is the court determining this matter? It's for the judge or for the sheriff to determine the matter. It's not a case of the court reporter. So there is a protection there. I think there is a level of protection that the court ought to be providing. Now, we can have a discussion as to whether that happens in practice. I think there is a more proactive approach. I think there's more interest by the court in these issues, which might provide a protection against the suggestion that there's reciprocity in a bad way on that. But I think that's one factor that needs to be taken into account.
Eileen?
Yeah, I mean, my understanding was that the idea behind the lists in the first place was to try and deal with this worry that perhaps there might be a bit of mutual back scratching going on. I think that was the original idea behind the lists. Certainly Glasgow's not been refreshed for a very long time, and people have come off the list, and I've never been aware of a mechanism for replacement. I think Aberdeen, as you said, is down to 3 now as well, and even the Court of Session list isn't as much as it used to be. So I mean, I think there's a bit of work to be done, perhaps further consultation to be carried out before we go wholesale into a new system. But if court reporting is to continue, then increased transparency and understanding by people about any lists that they are, an extended list, a national list, whatever it ends up being, can only be welcomed, I would have thought.
Okay. I'm very conscious of time. We're coming up to our hard stop. But I just wanted to thank you both for your participation, and also to thank everybody for staying with us through the duration of this webinar. If you do have any questions or queries that you want to follow up on, please do let us know. Otherwise, it's just for me to wish you both a great day. Thank you very much for coming, and also to everyone else, thank you so much for your participation.
Thanks, Lucy. Thanks, Sandra.
Bye-bye.
Bye, everyone.